there was a laptop on the witness stand, and you accessed it.
Yes.
And you actually did that without anybody asking you to, or asking the court's permission. And
we are back, Go ahead and hit that like button, y'all. Today we're going to get into a couple of the more interesting topics from an otherwise kind of dull day of just a lot of motions and that sort of thing. But the day did start off with a bang. Another ex parte communication, which we're going to get into right now. And also, Judge Whitaker called Sprinkel, DA Sprinkel, back to the stand to question him about something that I think we may have all seen previously. So we're going to get into that as well.
Good morning, Your Honor.
good morning.
I appreciate you forwarding to us the ex parte communications you received from Madam DA Fani Willis. Given the sensitivity and the history in this case of ex parte meetings or maybe communications, would you just please request the state? I understand probably what was behind that communications. And of course, it is great for a boss to buck up an underling who has perhaps been attacked or maligned. But I don't believe that, and I don't think the court does either, that the court should have been copied on that communications, especially one that reads maybe more like a campaign ad with a source story in it than anyway, I just don't believe it was appropriate, and I would just ask you to please ask the state to halt any future communications ex parte they might want to have with this court. That's all I have to say. Thank you, Your Honor.
Yeah, it's a shame that the court would even have to say something like that. But can you all please communicate to everybody in the DA's office to not have any sort of ex parte communications with the court? And y'all may not even know what I'm talking about because I don't think either of you was copied on that email, but Miss Love was. Miss Hilton, you were as well?
I do, Your Honor, and I don't know, I know exactly what you're talking about. I think we have a different perception of direct communication with the court, but we
But the
make
court
sure
was
that
copied on it. And it could have been an accident, but
and Your Honor,
it should have been careful.
but the state did not have the initial conversation with the court. That was
No, I
a
know
community member, and it was very much a reply. Also, was not a direct communication with the court, but we understand the court's perspective. We understand what the court is saying.
Oh, excuse me. I just need to take issue with the fact that it wasn't a direct communication from the court. I'm sorry. Excuse me. Can you hear me now? I didn't mean to act like Max Short. I take issue with any type of suggestion that this was not a direct communication with the court. It went from Madam DA Fani Willis to this court. It was a direct communication to this court. It was inappropriate. It was praising Georgia's RICO statutes to the court, which again was not appropriate, Your Honor.
Frankly, I think it might be a good idea to print out the email and make it a court's exhibit to this record. But I think what Ms. Hilton was just saying was that the original communication was not from the district attorney's office. The original communication was, I don't know who this person is or where in the world they are, but some member of the world, member of the public, emailing Miss Love directly, but copying several other people, the court included, because of course our email addresses are a matter of public record. And, you know, I basically ignored it and deleted it. But as you all know, because I forwarded the next communication to everybody, the elected DA, Ms. Willis, made a decision to respond and directed that response to Ms. Love, but kept everybody, including the person who had made the original email communication, and the court on her response to Ms. Love. And I believe that to be ex parte, and that is the reason why, as soon as I read it, I had Ms. Persifield forward it to all council, because I don't think that should be going on.
I certainly appreciated that, Your Honor.
And
Thank
the
you.
court really has ignored entirely the substance of the communication, because the court is not making any decisions based on whether I think the RICO statute is good or bad. That's not what judges do. The legislature enacts statutes. I apply them hopefully correctly.
And I have no
or
concern.
whether anybody thinks any attorney is doing a good or a bad job. I'm just sitting here trying to follow the law.
Yeah, and I'm not concerned about any impact on the court from that communication.
Yeah.
It's just the
Shouldn't be
communication
happening.
itself. Thank
Yeah.
you.
So, Ms. Persifield, if you don't mind printing that out. And I have no idea what court exhibit number we're on, but if somebody can figure that out, we'll number it court's exhibit number, whatever the next one is.
The defense asked the judge about this letter. This letter that was sent apparently to DA Love, and then somehow maybe she sent it over to Fonnie, and maybe she got shook, and Fonnie sent Love a response back, and Love must have sent that response on to the judge, which would constitute an ex parte communication because Love did not CC the defense. So first I'm going to read the original letter. Apparently this was the letter. This seems like a prank almost, y'all. It doesn't seem like Love could have really been worried about this letter, but I'm going to read it and I'm going to put it on the screen. So here we go. Dear Miss Love, I have been watching your behavior for quite some time now, and I'm wondering, how can you be so bad at your job after all these years of experience? The new judge, who was trying to help you, not as much as Earl did initially, is fed up with you finally. You are ruining your career and what is left of the reputation of the Fulton County DA's office. Please just rest this case or you will get into so much more trouble. Maybe you're going to lose your job and will have issues in finding a new one because your unprofessional behavior and your haphazard and unorganized ways of working are on display for everyone to see. Please just do the right thing. You're going to lose the case anyway because you lost the jury about 6 months ago already. And what's eventually going to come out is that young thug is innocent anyway. He's no effing Pablo Escobar, but you're acting like it. Just stop it, please, Miss Love. Kind regards from Germany. Now, we don't know if this person's name is Germany, like this is, kind regards, I'm Germany. Or if they're saying they are from the country of Germany. I don't know. I almost feels like I feel like I've been pranked, y'all. Did I read the wrong thing? Hopefully not. Hopefully not. I do find that they use the term gonna, Gonna, and they seem very familiar with the English language. So I don't know. I read somebody who said that this seems like a very German way of writing. I don't know. Y'all let me know in the comments. So now we're going to get into Fonnie's response to this. Apparently Love must have sent this over to Fonnie. Miss Love, please ignore this foolishness. As you know, the elected district attorney is extremely proud of you and believes you have Now, this letter seems like it's from Fonnie, but it also seems like Fonnie is speaking of herself in the third person by calling herself the elected district attorney. So I really don't know what's going on with all this, y'all. I'm just reading it. Y'all set me straight if maybe I got pranked, but I'm gonna read it. Miss Love, please ignore this foolishness. As you know, the elected district attorney is extremely proud of you and believes you to be a huge asset to this office and our community. You have no chance of losing your job and your service is greatly appreciated. Folks who have never tried cases will always have nasty things to say. But while they criticize from the sidelines, they fear the arena. They are not risking life and limb to keep our community safe. Let me tell you an anecdote of encouragement this morning. A good friend of mine called this weekend and said she was in an Uber and the Uber drive randomly began talking about being from Memphis and how much violence there was in Memphis. She said the Uber driver said Memphis, they do not have the ability to do RICO. He said, I am so proud of our DA here in Atlanta and her YSL team. They are not afraid, and they are fighting for justice. I tell you this random anecdote to encourage you to brush your shoulders off and keep your eye on the prize, which will always be justice. Please know that your boss gets 100 nasty messages and 100 nice messages a day. I focus on one thing every day, representing my community in a way that is fair. I'm asking you to continue to focus on justice and ignore the haters. I'm extremely proud of you. Now go make it an amazing day. Yours in service, Fonnie T. Willis. So Fonnie speaking of herself in third person here, looks like. That's quite interesting. So the defense took exception to this because this message, the one that I just read from Fonnie, this was forwarded to Judge Whitaker, but the defense was not carbon copied. So with this being forwarded to Judge Whitaker, this represented an ex parte communication because it excluded the defense. It was a communication between the prosecution and the judge, and the defense was excluded. As you can see, Weinstein wanted to make sure that this sort of thing does not continue, and generally speaking, would consider this very unprofessional. Now we're going to move on to the second thing. Here we're going to get into Sprinkel, into Judge Whitaker questioning Sprinkel about what the heck he was doing typing at the computer when he was on the stand recently. Of course, you would think that Sprinkel would have announced or somehow notified the court that he planned to use the computer, but apparently he didn't. After we get into this questioning from today, we're going to flow directly into what the judge was questioning him about, which was several weeks ago. And you're going to see how he was fiddling with the computer. And many people actually thought that DA Love may have been coaching him by sending him messages from her computer to the computer that he was using while on the stand. So first we'll get into the questioning from today, and we'll flow right into the previous situation that led to today's question. As always, want to give a shout out to Thugger Daily for bringing this content.
I wasn't gonna do this right now, but when I read that, go ahead and sit down. You're sworn. You're already sworn. You've been a witness in this for days on end.
Yes, Your Honor.
Okay, so you're still under oath, and I'm going to recall your attention to, I think it was the last day of your testimony, but it was, there was a laptop on the witness stand, and you accessed it.
Yes.
And you actually did that without anybody asking you to, or asking the court's permission. But can you tell me what all you looked at on the laptop?
Yeah, I had my supplement, that 140-page document, and I also had some of the stuff that I pulled during the case. Everything that's already been turned over in discovery, just in case I need to refresh my recollection. But primarily, it was just it was a digital version of the report that I had on the stand. That was it. So I could do word searches. So if I was asked a question, I wouldn't have to be flipping through pages and looking for things.
Okay. Was there any point in time when you accessed anything else other than that report and the files that were connected to that?
No.
Okay. Did you in any way read any communication that came in at any time from anybody?
No, I wasn't communicating with anybody. I didn't have email open or anything like that. All I was looking at was the report and the digital media, like the discs that I brought to the stand with me, that stuff that was on the discs and the stuff that was turned over in discovery. That was it.
All right. We may call you back at some point with regard to this a motion that has just been filed after lunch. Are you going to be around this afternoon? And I don't know whether you'd be needed for that or not. Haven't read it in detail, nor do we have a response from the state yet. But would you be available this afternoon if we need you?
Well, I'm just one floor up, Your Honor, in courtroom 2B. I do have a couple of cases, but I mean, the short answer to your question is I will be in the building in the moment I can peel
and
away.
I don't know, like I said, whether you'll be needed or not. But all right, thank you.
Okay.
You were not able to determine who it was that actually rented the vehicle, just that it was in the name of Jeffrey Williams. Isn't that right?
It was in the name of Jeffrey Williams, his driver's license number, and a signature. There's a signature as well.
Now, tell me the date that that vehicle was rented.
From what I remember, January 7th, 2015.
All right. So that would have been 3 days before January 10th of 2015, correct?
That's right.
All right. Now, tell me, if you can, who had possession of that vehicle on January the 8th of 2010?
2015?
What did I say, 2010? 2015, yes.
Yes. I don't know.
You don't know who had possession of that vehicle on January the 9th of 2015?
I do not know.
And you certainly don't know who had possession of the vehicle, no personal knowledge of who had possession of that vehicle on January the 10th, 2015.
If we're talking about actual possession, like the
Actual
person,
possession.
then no, I do not know.
Okay. You never strike that. By the time you came into this case, that rental vehicle, I mean, it had been at this point, what, a year since the incident? We're talking January 2016 is when you're in this case?
Yes, I obtained the records from Hertz in 2016. It would have been over a year. It would have been around April of 2016 when I obtained the records from Hertz.
Okay. Now, I want to ask you about some of the things you did not do. Okay.
Okay.
You referenced earlier there were a lot of numbers being phone numbers being kind of, I don't want to say thrown at you, but put in front of you in terms of, well, you were able to get information on this phone number and that phone number, the frequency of communication. Is that, you remember those questions?
I do.
And you did in fact have the ability to procure phone records by way of either subpoena or search warrant or court order.
That's correct.
Okay. You were able to get a lot of different phone numbers on people that you thought, or individuals you thought might have been of some interest in the case. Is that fair?
That's fair.
Okay. You also, when you request those phone records, you have the ability to request cell site or cell tower information, correct?
That's correct.
Now, and I know you're not an expert, but you are familiar with utilizing, maybe with an expert, cell site and cell tower information to try and make a determination as to where someone might have, or where a phone might have been at a particular time. True?
Yeah, I'm pretty familiar with plotting cell phone records. I'm not like an FBI CAS team member or anything like that, but I can hold my own.
Right. So having listened to Kenneth Copeland's statements, and you did that, all right? Mm-hmm. Having listened to his statements, one of the things that you would have wanted to do, I presume, I'm asking, is try and determine whether or not you could corroborate certain information in his statement. Is that about right?
That's about right.
All right. He gave, like we said, at least one 9-hour statement, and he gave a lot of statements. There was a lot to listen to from Kenneth Copeland.
Yes.
Right. And he gave information that you would have used to follow up in your investigation.
That's correct.
All right. The name Demekian Garlington came up in your investigation. Is that right?
Yes.
Right. There was this reference in listening to Kenneth Copeland's statements. There was this reference to a conversation, phone calls that he would have had with Garlington, right?
That's correct.
And it would have been some interest to you to figure out whether or not what Kenneth Copeland was saying, not just about that, but everything was corroboratable, was true.
Yes.
Right? Or whether Kenneth Copeland was lying to y'all, lying to the detectives, not y'all, because he had already been interviewed, right?
Right. That's right.
Because you considered him to be a pivotal witness in the case.
Yes.
Right. And some of the things that he said, you would have considered to be pivotal things that you wanted to follow up on, right?
Yes.
And if you have a witness, just like Spencer Wright, for example, if you have a witness who you think has pivotal information, but that witness is proven to be a liar, that's something that you want to know in regards to the investigation. True?
That's true.
And one of the things you could have done in regards to Kenneth Copeland and any statements he said, phone calls he said he may have had with someone named Demekian Garlington, is you could have gotten Garlington's phone records to determine whether or not those communications took place, right?
That is correct.
And also where Mr. Garlington was to see whether that comports with what Kenneth Copeland said, right?
That is correct.
Now, you got Kenneth Copeland's information, his phone information, right?
I did.
You got his location, so you knew, or at least the phone, where that phone was at certain times on the night of January 10th, 2015, right?
Well, to be specific, what you see with tower data is the tower and the side of the tower that the phone
Sure.
utilized. That can be a pretty large area. In a city with a lot of cell phone towers everywhere, you get a little bit of a better idea, but I just want to make sure that we're clear that it's not the exact location of the phone.
Sure. Not the exact, I mean, you can't pinpoint within feet or maybe not even within a block, but it was important enough to you to get that information on Kenneth Copeland on the phone that you thought was being used by Kenneth Copeland, right?
Yes.
Now, you did reach out to get information on Garlington's phone, or what you thought was Garlington's phone, right?
There was a number that I thought may have been Garlington's number.
Sure.
And I believe I referenced that in my report. And correct me if I'm wrong, I believe it was maybe a Sprint number, or maybe I can't remember exactly. It wasn't in his name. I was never the short answer to your question is I was never able to get tower data for Demekian Garlington.
Well, it's not that you weren't able to get tower data. You requested the data for that phone number and specifically requested it without the tower usage logs. Isn't that right?
Yes. So there was a number that was in Kenneth Copeland's records, came back, I want to say, to a female. Now, and I remember, and this is, I'm thinking, and unless there's something that can refresh my recollection, from what I remember, I couldn't prove. It's one thing to get call logs are very easy to get. You don't need probable cause for those. But to get location data, you need probable cause. And I remember, from what I recall, I didn't think that I had probable cause to get tower location data for this number. Usually I'll try to do something like, there's a number of things. Like if I find a jail call to the number and I hear the voice that picks up, I say, oh, well, that corroborates that number is in fact that person's number. Or if somebody cites it on their Instagram page and says, call me on this number, that's going to get me to probable cause that that's that number. But if it's just that it's in temporal proximity. And I think there was another issue with the retention period of the number. I don't, all I know is I didn't think I had probable cause. I never got probable cause to get the tower records for
Let's
that
work
number.
backwards a little bit, right? Let's start with this. When you sent out the request for the records that you thought was a number to Demekian Garlington,
Yes.
you requested those records specifically without tower usage logs, right?
I did.
Okay. Now, you had previously requested records for what you thought was Kenneth Copeland's phone number with the tower usage logs, right?
I don't know that it was me that did that. It may have been investigator or detective Dennis that did that.
Right. But one thing that you knew, I mean, you honed in on the fact that there was supposedly this call between Kenneth Copeland and Demekian Garlington, and they were supposed to be at a specific place on the night of January 10th, 2015. Isn't that right?
That's correct.
Right. And so you had listened to Kenneth Copeland's statements, and you knew from Copeland's statements that he made reference to a Garlington, who was an important witness to you, right?
It was.
Right. You knew that